Yes, Mr. Stuart-Smith, I've been thinking about black and blue taxis.
They were blue and red.
Or blue and red
I've been
taxis.
taken to task.
Yes, blue and red. And it occurred to me that it may not be right to throw up one's hand in horror and say, because of the blue and red taxi thesis, it's impossible to distinguish between the likelihood of one cause or another cause of mesothelioma. Because I suspect if you look at the blue and red taxi thesis, you would say it's impossible to evaluate whether you're more at risk of being knocked down by a blue taxi or a red taxi, because there are so many other factors that go into that risk.
Yes.
But the minute you say it is possible to differentiate between the contribution to risk, it seems to me it must follow as light follows day, that it's equally possible, on balance of probabilities, to decide whether it is more or less probable that A or B was responsible for the mesothelioma.
Well, my lord, that has always been my reaction. And the expositions of the blue and red cabs
Where does the red come from? I'm looking at Lord Mackay's speech in Hodgson, and it's blue and yellow.
Blue and yellow, yes.
Well, my lord, I think I went abroad and found it in Merrill Dow. I think there's one of the American authorities there. But that may simply be, depending on which city you happen to be sitting in at any given moment. And my Lord Mackay's instinct may have been to do with a taxi firm north of the border. I do not know.
No, he was quoting an American case.
Right. Well, anyway, the colours. Can I assume, for present purposes, that the precise colours don't matter? And the expositions of the blue and of the coloured cabs do always carry the qualification that if you have other information, then it may become perfectly possible. But I think the proposition is founded upon the absolute randomness of and equal likelihood of any of the number of cabs being at that place at that time. And that is how I understand the basis of the proposition. But, my lord, as I have said, I haven't come here to argue that the basis of Fairchild is correct or incorrect. I take it that in multiple exposure cases, that remains the position. There are genuine cases which throw up the genuine Fairchild.
Well, I do think you're in difficulty because you do suggest that it's possible to differentiate between causation when one's looking at ambient exposure on the one hand and occupational exposure on the other.
Yes. Well, it does seem illogical. It does seem counterintuitive that one cannot say in relation to multi-exposure cases, but one can in relation to a single exposure. The best that I can say is that you can normally use probabilities as a proxy for proof. And what you are, it's not precise, but it's the best evidence that may be available. And at the beginning, you are, at the stage that we're looking at, you're looking to see whether a tortious exposure or an exposure in breach of duty has anything at all to do with the mesothelioma. By the time you get into the Fairchild enclave, you are dealing with many more variables. By definition, you've got at least two competing causes, each of which could have been sufficient and so on. But as I hope I made clear yesterday, am not in a position to explain the difference. All I am in a position to do is to say that at the single exposure level, the prediction of risk has been done conventionally in this country as a basis for proof on conventional principles. There is no reason to, at this level, to exclude the possibility of doing so. Whether being able to do so in the single exposure case casts doubt on the Fairchild proposition, or whether the Fairchild proposition casts doubt on the single exposure proposition, is not something that I'm able to resolve for the court.
And isn't the problem compounded by Barker, which of course as it left the House of Lords, was on the basis that it is possible to discover the relative degree of contribution to the risk, probably measured by the duration and intensity of the exposure involved. That's from the head note, because that's what you have to do to have the aliquot attribution of liability and quantum.
Yes. Well, my lord, that may feed back into my submission, which is it's the best you can do. So that previously, under Fairchild, where the bald proposition was you can't discriminate between them, it was obvious that those responsible had to allocate the cost of the liability between them. And as was referred to in Barker, and may have been referred to, I think, also in Fairchild, what actually happened was insurers came to a pragmatic solution, which they agreed between them, that they would contribute broadly by reference to time on risk or whatever it might be. So in one sense, it feeds back into my submission, which is it's the best available. It's the best approach available.
Has there been a case where there's been a possibility that the cause of the mesothelioma did not involve wrongdoing? Because Fairchild and Barker, I think, were cases where it was simply accepted that it's quite obvious that the exposure was a tortious exposure. The only problem is that you can't decide which of the possible tortfeasors was responsible. Now, in that situation, one can see the need, the need for the Fairchild approach. And so nobody asked the question, what if on balance of probability you can show that it was this volcanic eruption that's much more likely to have resulted in the mesothelioma than the three different employers who were responsible for very low level of exposure?
Can I check my answer with Mr. Feeney, who will...
there are cases of mesothelioma where there's been no breach of duty.
Well, there have been a lot of cases, and I don't sure they've gone to trial, where there have been pre-65 employers who weren't in breach of duty. The practice has been to say that's irrelevant, that the employers weren't in breach of duty.
But have there been any cases where it's been proved that mesothelioma, held that mesothelioma was caused by exposure but no breach of duty? Apart from those?
No, not about those.
Well, in relation to... There have been cases before involving exposure before 1965 where there has been no real doubt that an exposure has caused the mesothelioma. But because it was 1965, they have not been... I think the position is they've not been taken to trial because of date of knowledge and arguments about date of knowledge.
Innocent exposure as opposed to cautious.
That's right.
Yes.
That's right. But neither I nor Mr. Feeney are aware of a case where a judge has held that the exposure was caused by, the mesothelioma was caused by exposure, but not attributed liability to it. Correct.
I mean, Fairchild was, as I understand it, on the basis that one thing you could discount was that the cause of the mesothelioma was other than the inhalation of asbestos dust work. I mean, that was condition 5 of Lord Bingham's 6 conditions. So it had to be work-related, and I don't know, I wasn't in it, my daughter of course was. There were obviously other employers in the background who they hadn't been able to trace or were uninsured, but nobody seems at that point to have discussed the possibility of non-negligent
No. And
work-related exposure. But of course, by the time you get to Barker, people are very explicitly discussing that and say, well, that doesn't matter. But that's on the basis that you allocate only a part of the...
Exactly. And my lord, as I said I would yesterday, there were two things that I read overnight. One was Professor Burroughs' article, and I've handed in a number of extra copies for the court. where, as it seems to me, that the main thrust of his objection is an attack on the notion of a single causal agent. Now that, the other thing I read last night was the case that we had prepared for the appellants in Barker, and it's adverted to in the judgments that the basis upon which I invited the House of Lords to apportion liability was not the basis upon which certainly Lord Hoffman and Lord Scott decided that it should be done. The submission that we, and this is of some relevance to the present case, I think, the submission that we made was that when you have adjusted the rules for imposing liability, it is fair to adjust the amount of liability which you impose. That's a very broad, and that was explicitly not accepted by the majority. But we also had, in those circumstances, the mechanism that we proposed was not accepted by the majority.
What was the mechanism? I can't remember. I remember that proposition, which was accepted by the majority.
Well, we simply said that we didn't propose any changing in the nature of the tort or anything like that. We simply said...
You never argued for risk.
I did not as such, no. But I did argue that you could, if you decided in principle that the measure of damages would be several and not joint because of the exceptional nature of the imposition of the liability, in those circumstances you would probably look to the contribution that each employer had made as being the best measure for making any allocation at all. But Lord Scott and Lord Hoffman led the charge. I think it was Lord Scott's idea in the first place, as I remember, and dealt with it on the basis of, as you've seen in the judgments. Now, the other feature of the argument that had to go with that was that we still had to distinguish Wiltshire. And the prerequisites for which the appellants contended in Barker for the Fairchild exception to apply were first that it only applied to indivisible injuries, that was not controversial. Second, that the defendant's wrongful act had increased the risk of suffering. That comes straight out of McGee and Fairchild, obviously. Third, that the etiology of the injury is unknown and couldn't be known because of the limitations of medical science. And that wasn't really controversial. What was controversial was the fourth, because the appellants tried to hold the line at Fairchild and McGee. And so we submitted that the fairness of Fairchild depended upon an understanding that the injury had been caused either by tortious behaviour or by behaviour under the control of a tortfeasor, which, for whatever reason, was not itself tortious, that being McGee. And so the argument that was advanced for the appellants, but not accepted because of the single causal element was taken as the touchstone, was that the injury had to have been caused either by the defendant tortfeasor's wrongful act or omission, or a similar wrongful act or omission of another tortfeasor, or a similar but lawful act or omission of the same defendant or another tortfeasor, that being to cater for McGee. The justification being that you could at least say that the non-tortious contribution of a tortfeasor was under their control, the McGee problem. Now, but that's not, unfortunately, well, I would say unfortunately, but I would say that, that's not the way that the House went, as I read the judgments in Barker. And that is one of the sources of our difficulty. Because if that analysis had been followed, then Mr. Barker's appeal, the appeal in Barker would have been allowed because of his contributory negligence. And that was too much for the House. So I don't know if that helps at all in relation to what I was making submissions about yesterday, but I believe that is how it came about.
In Fairchild itself, at least one of Mr. Fox had been employed from 53 to some by one of the defendants, who then went on. So that was a defendant who therefore would have had both tortious and non-tortious exposure, because he would have been prior to 1963 or whatever the date is you take. As
I don't know the facts with sufficient detail to know,
but
certainly that was the period of his
it's
exposure.
recorded by Lord Bingham.
It is recorded by Lord Bingham. What I do not know is whether it was presented to the House on the basis that some of that exposure was non-tortious. I wasn't there, Mr. Allen was there.
Yes, I'm not sure I remember. But I mean, certainly I'm sure in Barker we were told that the date, whichever it was, there is a sort of notional cut-off date, isn't there?
There was an effective notional cut-off date, and that cases tended not to come to trial.
But I mean, I thought, maybe I'm wrong, or maybe I'm just using my knowledge of what I know happens in other areas, that there was that when you come to divide it up, you only count periods after 1960, whatever it is. Am I wrong?
October 16th. It's not a complete defence pre-65. No. It's only defence to light exposure.
I think, my lord, there was no absolute cut-off under the ABI scheme, and the pre-65 marker was in relation to light exposure. It wouldn't have helped a defendant who'd employed someone as a lagger or something like that, who had exposed him to huge amounts. Well, my lord, that is my dim recollection, and it's confirmed by Mr. Feeney, who has a much more detailed knowledge.
Well, I shall bow to Mr. Feeney.
Well, I always bow to Mr. Feeney on that stage, but I don't think he would demand that your lordship. That was what I was going to say, arising out of Burroughs and Barker from yesterday. There is one other thing. We looked at the Weekly Law Report's report of the first instance judgment in Hodson, and it does not reveal the nature of the evidence upon which my lord made his findings.
No, I also have been shown it, and there comes a point where it says that the evidence was examined.
That's right.
It's not included in the actual report.
That's right. That's right. So that is all I can. So I can't assist the court any further on Hodson. There is one thing which I said yesterday, which I believe on reflection was probably misleading, and can I correct that straight away? I said that Peto had found no variations between health authorities when discussing the measure of risk, and that was left in that way was a misleading statement. What in fact Peto said was that their main analysis had been by job occupation, and that they had not found that analysis to be confounded by reference to different health authorities or health areas. So they do not say that there isn't a higher incidence in Tyneside than in Orkney. What they were saying was that even though there may have been higher incidences between health authorities, it didn't confound their main analysis, which is different. And I wish to correct that.
Can I just go back to Lord Brown's original point? What's your answer or submission in relation to the oddity that the Fairchild rationale, on one view, the impossibility of assigning causation derives from the impossibility of forming any view about probabilities? And, on the other hand, the Barker result, which is that there should be allocation of loss according to risk.
My submission is that it is a classic case of the courts addressing a situation which cannot be fully resolved simply by the application of logic, and that we know that the law of causation is not simply a logical exercise. It's policy-driven. And there are any number of citations, and I'm not sure whether I mentioned that there are citations even in Fairchild, where Lord Bingham and Lord Hoffman in particular say this is not something which is susceptible simply to detailed analysis. And so if you give yourself that liberal freedom, it is not inconsistent in that sense to say, for the purposes of establishing the Fairchild exception, that you cannot decide whose asbestos has caused the mesothelioma, and yet, because you have to allocate responsibility ultimately, to look for the best proxy that you have, which is contribution to the risk, it being known that an increase in dose increases the risk.
It might be less misleading to have spoken of contribution to exposure rather than contribution to the risk. Because if
it might,
exposure doesn't pro-rata increase the risk.
An extra sentence could have been put in,
Yes.
because there is one of the uncertainties is, or one of the variants is what sort of asbestos you've exposed and things which cannot be measured with absolute precision. And it is that, my submission is that it is that lack of precision, or the lack of the possibility of precision, which underlies this whole area of difficulty. And it's the lack of precision and that gave rise to the Fairchild exception in the first place. And therefore one shouldn't necessarily feel bound to call for absolute precision when dealing with the consequences of Fairchild. And that is why yesterday I made plain that I was not calling for a strict mathematical bell ringing at a relative risk of 2.
But you are asking us to draw conclusions as to probability, which is essential factual matter, and yet the scientific foundation of Fairchild might, on one view, be that that's factually impossible to do.
Well, Professor Stapleton, in the article which I know you've read,
yes,
at page 354, argues for it. It's at these times like these that one has to remind oneself that Professor Stapleton didn't contribute to this case and is not always right.
She usually has an interesting view, which is markedly
She
different
always,
from anybody else's.
She always has an interesting view, and it always demands respect because of her extraordinary powers of analysis and her analytical approach to things. But we are dealing with a case here where we have various set points. We have Fairchild saying it can't be done in a multiple exposure case. We have, both in this case and in other cases on the other side, people asserting that in what I call a single exposure case, you can form a view on the basis of evidence of risk. And you have Professor Stapleton saying she doesn't agree. And I couldn't say any more.
Well, I wasn't relying on her.
No. But I'm sure I know Mr. Melton will because he cites it in his
Yes,
in his case.
Yeah. Well, thank you.
It seems to me, prompted by my Lord's question, that actually most of the problem is scientific evidence, isn't it?
Yes.
In my own field, when one had the problem of trying to work out which of 2 parents had injured a child, you could never know. It would only be one of them. So it's the single fibre. You don't know. And you look at all the various bits of evidence that you've got and work out which is more likely than not.
Yes.
And that's what you do in most areas of the law.
Yes.
The problem with this area of the law is the scientific evidence seems to stop you doing that.
Yes.
But I'm finding it difficult to work out why.
I
Yes.
agree.
I agree. But the case, sadly or not, the case which asserts that you can and has laid the foundation for a submission that Fairchild is based now on a false premise is not before the court. I hesitate to venture into your specialist field, but yesterday in the press it was said in relation to baby P that it is a known risk factor when a non-biological parent comes into either a single-parent family or replaces. Now, that's not something, obviously, I knew, and I don't know whether it be true, but if it were true, a trial judge would not exclude that from consideration, I would respectfully submit, although the trial judge would undoubtedly hope that that wasn't all that he or she had to go on.
He would have more than that.
He would undoubtedly have more than that. Absolutely. But in these cases, what, as we will see with Judge Mayne, What he did was to he examined the evidence fully, fairly, and clearly, and made specific findings. He then made a qualitative assessment, which was that this was very light exposure, and then he went to Dr. Jones's evidence for guidance or support for his view that it was very light exposure. And in my respectful submission, that is an approach which cannot be faulted. But I was going to come to that in about a quarter of an hour, if I may. There were two points in the... Can I tell the court where I think I've got to?
Yes.
There are 2 points in the respondents' cases which I need to address directly, and I don't think they will take very long. Then I was going to come to Section 3 of the Compensation Act, which is a short point of construction where we have put our analysis in complete detail, or virtually complete detail, in our case. And therefore, unless I was asked questions, I was not proposing to spend very long on that at all, simply to highlight in about 3 or 4 sentences why we say the Court of Appeal was clearly wrong on Section 3. And then I was going to come to the individual cases. And in relation to the individual cases, we have given you references for the proposition, the factual propositions where we say this was the evidence. And I was not proposing to take you to all of them, but there were some references which I was proposing to, but if at any stage I'm stopped, then I will stop. And can I then deal with the last 2 submissions that I was going to make in relation to material increase of risk? And the first arises out of my learned friend Mr. Allen's case in Willmore at paragraph 3.3, which is on page 9 of his case. He's dealing with the contention that the Fairchild exception is not engaged in a single exposure case, and he makes the point which I addressed yesterday, that it's logical when some mesotheliomas are caused by asbestos exposure in the ambient air. But then he says this: an individual's exposure to asbestos in the ambient air will vary greatly depending on where they live or work. If they've lived or worked in the vicinity of an asbestos factory, they may well have experienced significant exposure to asbestos. And he refers to the case of Margerison. Can I come to Margerison in a moment? But in relation to a single exposure case, I accept that exposure, the exposure from the ambient air may vary from place to place. And in a single exposure case, proof of causation might require that to be taken into account. Again, depending upon the ability of the evidence to address the point. That is not unreasonable. It is no greater imposition than is imposed on other claimants who have to prove causation on normal principles.
It may also vary, I suppose, depending upon the age of the claimant or deceased.
Yes.
Because the older you are when you contract the disease, the longer you've been exposed to the cumulative ambient.
Yes, yes. And one of the things which I didn't know before encountering Dr. Jones in this case is that certainly on their model, time cubed has the contribution of time is a cubed function. It's not just linear. It's not so that my Lord's point is well made.
I'm sorry. I mean, on the facts of Sienkiewicz, 24 cases per million is the background exposure, the
yes.
environmental exposure.
Yes.
And that presumably takes account of A, where she's lived, and B, for how long she's lived. Is that
yes,
it?
that was a lifetime risk.
In a particular place.
On the assumption that she was exposed to urban
Exactly.
levels of
Exactly. So those are the considerations in assessing that degree of risk.
yes.
Okay.
The time is always a constant so far as the figure that you're looking at is concerned,
Well,
not when you come to consider causation.
I may be misunderstanding the question, but the calculation of the lifetime risk
Yes.
takes account of time, but in the model that Professor Jones and the
Yes.
Institute of Occupational Medicine have developed, the effective time is not simply linear.
Yes, but the model that enables you to say lifetime
Yes.
risk is A, is a model which takes a single working lifespan
Yes.
for those purposes, and then you would have to adjust that model depending upon the actual lifespan of the individual.
Well, not necessarily, because what you're looking at, and this is a point that the respondents make, that she died at the age of, I think, 73.
Yes, well, in her case,
But what you're actually looking at is the risks to which a person in a lifetime are exposed. And the fact that the risk, in fact, eventuates before the age of 80 doesn't nullify the validity of looking at the risks for a lifetime.
Well, I can see it doesn't nullify it if you're looking for a standard of what is material. But it does seem to me that if you're looking at an individual case of causation, you've got to have regard to the individual lifespan that's involved.
But I'm not if you're looking at it as being curtailed by the disease, by the outcome in question, because the lifetime risk acknowledges that it may happen at any stage. So what you are looking to do is to compare or predict lifetime risk both from ambient and from exposure.
The figure of 24 cases per million, background thing, is that just a general statistic? And
No.
Or does it relate to Ellesmere Port?
What it was based on an assessment based on general figures, not specific to Ellesmere Port. So, and Dr. Jones offered the judge his calculation on the basis of what he understood the evidence to be. The judge then adjusted it for, or made findings, certainly in relation to prediction of the occupational risk, to take into account his actual findings. Now, in relation to the figure of 24, I would accept, as I accepted before the Court of Appeal, that Mr. Melton achieved answers from Dr. Jones perfectly properly, which would reduce that figure. His best case would be that it would reduce it to about 10. And that's because of whether the proportion of amosite and chrysotile was rightly reflected in Dr. Jones's figures. But the position that I adopted before the Court of Appeal, which I maintain here, is even if you take it down to about 10, you are still miles off a relative risk of 2. And so, although the judge referred to 24 per million, I would not wish the Supreme Court to think that I was saying that that was a figure that was set in stone.
I'm quite surprised that that isn't in the statement of facts and issues, I have to say. I mean, if we're to work on some other figure, but there it is.
Well, the difficulty, I take the mark, the difficulty is that what that other figure should be precisely could be a matter of debate, which is why I have, before you, taken what I understand to be the best possible position for the claimant, which would reduce it to something in the region of 10, 12 or 10. My Lord, may I go back to the point that I was addressing? Margerison is in bundle 1 of the authorities at tab 13. And this was, in fact, two cases, both brought against Roberts, who are manufacturers of asbestos in Leeds. And the court will remember that Mr. Allen's skeleton refers to Margerison as as increasing the ambient level. Whereas in fact, what happened in Margerison was that on findings that the defendants had deposited enormous quantities of asbestos outside their...
For some reason, my bundle doesn't have number 13. I've listed out.
that is unlucky.
It is unlucky.
Pages 415 to 420.
I've been spared those.
Could we pass up a... For now, my lord, could we pass up a...
Thanks,
step?
sir. Front window.
Okay.
Thank you. Thank you very much.
My lord, the background is set out in the judgment of Lord Justice Russell on page 416 of the bundle, 359 of the report. In the third paragraph, close by the centre of the city of Leeds in Yorkshire, there's a district called Arnley. It was there that from the late 19th century until 1958, the defendants occupied a factory producing commercial products, which involved in the course of their manufacture a very extensive use of asbestos. And then describes how the plaintiffs lived close to the factory. And it was their claim against the factory owners. And if you go over the page, page 360, first full paragraph, we deal now with the facts. The evidence was overwhelming to the effect that beyond the perimeters of the factory on all sides, asbestos dust was deposited in enormous quantities. And that was, and then they go, the judgment goes on to describe how children played and how people would come home covered in dust and so on and so forth. And in the face of those findings, not surprisingly, the appeal against a finding of breach of duty was rejected. Now, the reason why I take you to Margerison is this. If you have, I have accepted that ambient air may vary from place to place, but if you have something like Margerison, what you have there is a controlled exposure, or an exposure under the control of an identified individual, in this case an asbestos manufacturer, and it is not to be equated with normal ambient air. And the remedy there is to identify the person who has deposited these enormous quantities of asbestos on the inhabitants immediately around, and they are then a proper defendant, as was the case in Margerison. So that is my response to the passage I took you to in relation to a single exposure case. In a case where the Fairchild exception applies, I would submit that if the evidence permitted a level of precision which took into account the higher level in a particular place, then that could and would be taken into account. But if not, then norms based upon epidemiological findings are the next best position. And that is the approach that was adopted in Sienkiewicz, where the levels were not made specific to the area of Ellesmere Port. And of course, if that has the effect of increasing the level, assumed ambient level, then that favours the claimant. If it is appreciated that that may operate in the opposite direction, that is something which a trial judge can take into account in his assessment.
I'm sorry, Mr. I mean, if in Margerison the deceased had also, as it happened, been employed by somebody who had likewise exposed them to some asbestos, then is it's a Fairchild case, is it? Because
no, Sienkiewicz, if Mrs. Costello had been employed by...
in Margerison.
In Margerison.
Margerison. I mean,
yes.
There, then you've got exposure at work, and you've got exposure because you keep walking past this factory in Arnley.
Fairchild.
So it's Fairchild.
Fairchild. The second point and last point in the respondents' cases that I wanted to pick up is, again, it appears in both cases, but can I take it from page 14 of Mr. Allen's case in Willmore, at paragraph 3.13.2.
Sorry, Willmore, paragraph what?
3.13 brackets 2 on page 14 of their case. Where it is submitted that authority indicates that there is no requirement for tortious exposure to be capable of causing the injury on its own, and reference is made to McGee, citations from Lord Reid and Lord Salmon. When one views them in context, which I will ask you to do in a moment, one can see that what is being talked about there is causation of injury, not contribution to risk. Could we go to McGee, please, which is in bundle 1 at tab 14. And the first passage relied upon is on page 4 of the report, page 424 of the bundle. At letter D. Where Lord Reid said, it has always been the law that a pursuer succeeds if he can show that the fault of the defender caused or materially contributed to his injury. There may have been two separate causes, but it is enough if one of the causes arose from the default of the defender. The pursuer does not have to prove that this cause would of itself have been enough to cause him injury. That is well illustrated by Bonington. Well, that is Hornbook law, but that is talking about where you have an aggregate contribution, or you have two contributions, which between them cause the outcome. And it is not, in those circumstances, necessary to prove that either on their own would have caused the outcome. But that is not the proposition for which we are contending. It does not apply where what you are considering is contribution to risk, because if that contribution to risk is not of itself capable or reasonably capable of causing the injury, then there is no need to treat it as if it has done so. And the other passage cited is to the same effect. It is at page 11 of the report at letters G and H.
I find that statement a bit difficult. If contribution to risk is not itself capable of causing the injury, then it's not a contribution to risk in the light of medical knowledge.
Well, what I wouldn't suggest that was entirely right, because you could have an exposure which itself should be regarded as de minimis, but does, at least to a small extent, add to the aggregate exposure. So you can say it contributes to some extent to the risk.
I thought the whole point of Bonington is it's a cumulative injury.
Well, that's why I made the point yesterday that it's a cumulative injury. It was treated as being an indivisible injury where the exposure in aggregate was what was required to cause it.
Exactly.
That's right. Now, it's in that context that I accept that these statements are Hornbook law. But the point that I'm making is that it does not apply to a liability for contributing to risk.
Why? I mean, if it's a cumulative risk, why does the same not apply?
Because if viewed on its own, the court Well, it's a cumulative risk in a doctrine which assumes that risks may operate in the alternative.
I'm not sure I followed that. I just didn't follow exactly what you meant by that.
It is accepted, two of the features of Fairchild are, it is accepted that risk increases with increase in dose. But one of the sources of the problem is that it is not known whether it is A's exposure or B's exposure. And therefore, if you take the view that viewed on its own, A's exposure would not have caused would not have led to a conclusion that it caused the mesothelioma, I'm harping back to a submission I made yesterday, there is no justification for bringing it in as being a potential, as being an exposure which should be held entirely liable for the outcome.
I mean, any material contribution to a cumulative injury like in Bonington, you can point to the defendant and say, you did contribute, because it's cumulative.
Yes,
But if it's risk, then you can't say the same thing, because the risk might not have actually had anything whatever to do with the matured injury.
well, my lord, I think that is a better way of saying what I was attempting to say.
I mean, the rule in Fairchild says that because you can't prove in the normal way, you base it on risk, and then you hold. At least I thought we held in Fairchild in that situation that the claimant has proved.
Unless it's de minimis, and the reason
exactly.
what I have been struggling with for the last day and a bit is to try and find a way of enunciating and articulating what is a de minimis. And unless I'm specifically invited to do so, I'm not going to go back over that territory again. Can I leave material increase in risk and go on to the Compensation Act and the effect?
Go on to what?
The effect of the Compensation Act.
Oh,
Section 3.
Yeah.
My lady, my lords will know that we deal with this in Section 4 of our case, which starts at page 21. The Act is at tab 5 of the authorities bundle, and the relevant provisions we have set out in our case on page 22 and 23. If one looks at the Act in tab 5, certain things immediately spring to the eye. On the first page, which is page 93 of the bundle, we see that although Part 1 is described, it comes under the general rubric standard of care, Section 3 is indexed as mesothelioma damages, and then when one goes to the page 95, one sees that the Act is to specify certain factors that may be taken into account by a court in determining a claim in negligence, and that is dealt with by sections 1 and 2, to make provision about damages for mesothelioma, which is obviously section 3. And section 3 itself is headed mesothelioma damages. Now, as we have set out in our case, subsection 1 is setting out the criteria for when the section applies, and it says so expressly at the beginning. This section applies where? And the fourth of those prerequisites is subsection or paragraph D, and so it is a prerequisite to the section applying that the responsible person is liable in tort by virtue of the exposure mentioned in paragraph A in connection with damage caused to the victim by the disease, whether by reason of having materially increased a risk which is a clear reference back to the Fairchild exception, or for any other reason. Now, on the basis of that, the Court of Appeal dealt with this at paragraphs 27 to 35 of the judgment of Lady Justice Smith. And we have set out in our case in detail what we say about this section of the Lady Justice's judgment. And what is strange, we submit, is that having accepted, as she did, that the statutory purpose or the intention was to reverse the decision in Barker so far as it held that there should be apportionment of damages, which she accepted in paragraph 28 of the judgment. She then, having set out the terms of the section, which unfortunately contains a number of misprints, which I don't think I need trouble the court with.
Well, there's a missing no in
There's a missing no in
2A2.
That's right. And in 3A, one responsible person from claiming it should be. But that does not form any part of the learned judge's reasoning. The proper terms are as in our case and in the statute. The reasoning is entirely in paragraphs 33 and 34. And we submit that the error can be traced to the second sentence of paragraph 33, where Lady Justice Smith says, "It seems to me that Parliament was setting out as conditions those matters which would have to be proved for common law liability." And we submit that on a simple and straightforward and clear, or even a more detailed reading of the section, that is not what subsection 1 does, because subsection 1 is setting out the criteria or prerequisites for the section to apply. And it says nothing about extending the scope of liability or where liability will be imposed. On the contrary, as one of the prerequisites to its application, subsection D requires that the responsible person is liable in tort.
Do you say that that sentence actually affects or infects her reasoning? And if so, how?
Definitely, because rather than recognising that subsection 1 is laying down the criteria for the application of the section, which when it applies changes the measure of damages once liability has been established, she approaches it as setting down the things that would have to be proved for common law liability. And one can see as one follows through 33 and 34 that there is, she accepts in 34, in the second sentence, which is line 3, I would accept that it was Parliament's intention to reflect the common law requirements of causation. But then the next sentences don't really add to the argument. And then 5 lines from the bottom. However, in my view, Parliament used clear words which provide that in all mesothelioma cases, a claimant can take advantage of section 3.2, provided that he can satisfy the 4 conditions in section 3.1. And the 4th condition can, in my judgment, be satisfied by proof of causation by reference to a material increase in risk. So she appears to be going back to her earlier error of suggesting that the criteria in subsection 1 are relevant to the test to be applied when determining whether there is liability, as opposed to determining whether the section applies with its consequences for the quantum of damages. So our submission is that there has been a fundamental misreading of the section. The four criteria are clear and are, as they say at the beginning of the subsection, the prerequisites for application of the section. One of those is that there should be liability in tort. And the words in brackets at the end of little d make clear that the draftsman is aware of Fairchild. So it's liable in tort, whether you're liable in tort because of the application of the Fairchild exception, materially increasing a risk, or for any other reason. If you're liable in tort, then the section applies. And that's the submission. And I'm really not sure that I can elaborate it much further.
So I'm sorry, so can I just be clear, I understand? You're saying this section, so to speak, doesn't bring into Fairchild cases that are not already there?
Correct.
I mean, that's the limit of your submission.
Correct.
And nor, of course, does it tell you what material and immaterial increase is if you are in Fairchild.
Correct.
Yes.
My Lords, unless I can assist you further, we have tried to set it out as clearly as we can.
Yes.
On this point, I've got a little more to say on other things,
yes.
but on this point, unless I can assist you further, I hope that our submissions are clearly made in the case.
Yes, they are.
And I'm not being, I think, unfair to my learned friend's case when I say that his case doesn't address the points that we have made, but we may hear more.
As a matter of interest, what other criteria for liability in tort are there than those which are identified in section 3, subsection 1?
Well, it covers... sorry, could you...
I mean, what other criteria are there for liability in tort? Negligence and breach of statutory duty, contracting leases and because scientific impossibility leaves open what exposure and leaves open your argument that ambient exposure is not sufficient. And then D is liable in tort by virtue of the exposure, whether by reason of having materially increased a risk, you rely on that, or for any other reason, well, you would say there isn't any other reason.
Well, I say that
so what other criteria do you say that should be referred to?
This would still apply if it were possible to prove causation on conventional basis, or for any... The words are entirely open. Whether the draftsman had anything specific in mind, my suggestion is, which I would accept is off the top of my head, is that the draftsman wanted to make clear that they had in mind here a Fairchild type of liability and put in or for any other reason, just to make sure that no one argued that it only could apply in particular circumstances. And so it's a catch-all.
Your causation point's dealt with by C, isn't it? I mean, if you can... the whole premise is that it's not possible to determine
Yes.
What the cause was.
Yes. So I would submit that the draftsman is simply being cautious, but with the words in brackets, and allowing for any eventuality. But what he is not being cautious about is that the section doesn't apply unless the responsible person is liable in tort.
What's the significance of the words "with certainty" in little with certainty in little c?
My submission is that it can only be referring to legal certainty on the balance of probabilities, because there is no other relevant meaning for it to have. Whether in a clause that was pushed through Parliament very quickly, it is right to submit it to the same level of textual analysis as one would to a section which had been gone through committees and all sorts of things, I would respectfully question. This section holds the record as being, as far as my researchers go, as being the quickest response to what I would say was the government's success in Barker. But I would say that too. And certainly the 1963 Limitation Act took at least 3 times, I think 2 or 3 times as long to get onto the statute book, and that's the nearest contender. So, my Lord, I would...
This is the nearest contender. I don't know.
But answering my Lord's question directly, certainty can only mean legal certainty, which is on the balance of probabilities. That is my submission. Unless I can assist you further on section 3, I was going to now come to the two specific cases. And again, we have tried to make our submissions clear in our case, and we have given references, specific references, where appropriate, to the material which is before the court. But the first thing that we do at the bottom of page 26 of our case is to draw attention to the rather odd structure of the judgments, because Lady Justice Smith expressly did not determine the common law issue, because she then went off and determined the section 3 issue, and therefore said it wasn't necessary to do so. Lord Justice Scott Baker agreed with Lady Justice Smith, and Lord Clark, having carried out his own review, then said he agreed with Lady Justice Smith that the principle in Fairchild applies to the facts of this case. And that is at that we see in his judgment.
55.
Yes, at 55. There is no doubt that this case developed as it went along, but Lady Justice Smith acknowledged at paragraph 6 of the Court of Appeal judgment that the defendant's case before the trial judge had been that Mrs. Costello's mesothelioma had been of idiopathic origin, and that was reflected in the opening submissions, and unless you wish me to do so, I'm not going to take you to those references. Those are references to where Mr. Feeney, before the trial judge, made his position clear. And you know that after conclusion of the lay witness evidence, the experts went away and produced supplemental reports, and I think also a second joint statement. Dr. Jones produced his supplementary report, which is in the bundle, which he said which was said to be for illustrative purposes. And again, I have given you the references there, and don't propose to take you to them unless you wish me to do so. And then 5.5 and 5.6, Mr. Feeney submitted that this was a case where the cause was unknown, but the trial judge made a finding which I can't subvert, which was that it was caused by environmental asbestos exposure. Now, on page 29, we deal, and I would like to leave it as we have put in the case, with the progress and the admission of Dr. Jones' supplemental report, and expressly in cross-examining Mr. Jones, Mr. Melton, which I think I ought to take this. I'll find the reference to this in a moment, said that he wasn't making a great issue about the admission of Dr. Jones's evidence. It wasn't contended at trial or in the Court of Appeal that this was a case where you couldn't do an exercise. It was simply said that Dr. Jones's evidence was spurious, or exercise was spurious because it was insufficiently reliable. The court knows that a major attack was launched on his evidence in the Court of Appeal, but that did not succeed. And what I would like to do, if I may, is to briefly take the court to the judgment of Judge Mayne to see how he approached his problem. And could we start in the judgment which is in part 2 of the appendix. No, it isn't. Sorry, that's a wrong reference. It's in
Part 1 at page
part
25.
one of the appendix, starting at page 25. Could I pick it up at page 35? Where over the next 10 pages, the trial judge identified 13 alleged sources of exposure which were being contended for by the claimant. And that took him up to page 45. He then did a general review of the expert evidence. And first, at paragraph 39, 40, and 41, he dealt with the medical evidence. And at the bottom of page 45, he found that the pathological evidence was consistent with low-level exposure to asbestos and not inconsistent with environmental etiology. And then he referred to the statement of Dr. Lawrence, which is set out at paragraph 40, which, rather like the similar statement from Dr. Rudd that we saw yesterday, ends with a statement which was taken as being effectively a legal statement, because Dr. Lawrence had said, if it can be shown that Mrs. Costello was exposed in one or both of these occupations, then such exposure should be considered as being causative of mesothelioma. And that was taken by the judge, and I think taken on all sides, as relating to legal causation as opposed to medical causation, because, of course, in terms of medical causation, it would fly fully in the face of Fairchild. He then came to the evidence of the respective engineer stroke occupational experts, Dr. Jones and Mr. Taylor, starting at page 40, paragraph 44, and he recognized that each of them had different strengths, so that Mr. Taylor was very authoritative on the practicalities of heating systems, but then at 46, or it's still in 44, end of line 4, Dr. Jones was much more authoritative on the issues of qualitative concentrations of asbestos fibres, on the toxicology of fibres, and general risk evaluations on inhaled asbestos fibres from an epidemiological perspective. And then at 46, he also referred to the relevance of the evidence in the first 3 lines of 46. Having established the facts, it seems to me that the evidence of Dr. Jones came into its own as the more authoritative guidance on the likely concentration of any potential source. And at the bottom, having referred to the fact of the very steep gradient, whereby if you were 20 or 30 feet away from the emission, your exposure would be about 1/10 of what it would be if you were close by. He then says at the bottom of that page, page 47, I found Dr. Jones' approach to be persuasive, but in my judgment it was important not to lose sight of the fact that a slight change might well significantly change the likely mean values of exposure. Ultimately, these are questions for me. At best, the evidence of Dr. Jones provided a guide by which I could broadly assess the likely occupational impact. So he had clearly in mind limitations in the value of the evidence. And then starting at page 48, he conducted a detailed review of the evidence, dealing with each alleged source and finding in relation to most of them that there was no evidence of exposure from the alleged source, and in relation to some, that although there might have been some exposure, it would have been de minimis. So, for example, on page 50, at D1, he took the view on the evidence that damage to corrugated cement sheeting and other similar asbestos products would have led to the escape of asbestos fibres into the factory atmosphere, save for the work entailed in the demolition of Bay 24, we didn't worry about that, and the sawing of such cement boards in the construction of a new bay. I cannot see that such escapes could have been anything other than de minimis, that there would have been a period when fibres would have been moving about in the air currents. This review was, I think, described by the Court of Appeal as conspicuously careful, and it goes on through to page 55, where, for example, he concludes in relation to dry sweeping of asbestos and circulation of dust that he does not find as a probability that there would have been any exposure. And the nature of his findings were that any exposure would have been light and intermittent, not least because Mrs. Costello would never have been close to the admission of asbestos. And then in paragraph 54, which is at 56, he proceeds from his qualitative assessment through to look at the evidence of Dr. Jones. And at the beginning of 54, he said, on any basis, in the light of the findings I have made above, the extent of Mrs. Costello's exposure to asbestos can only, I think, be described as very light. Indeed, her exposure will not have been directly through any involvement by her in any factory process, and so on. At 55, he tries to put it in context by reference to what would now be, if not permitted, but understood levels of exposure. And at 56, he refers to Dr. Jones's evidence indicating a very low predictive risk. So that's at 55. At the bottom of page 56, Mrs. Costello's estimated exposure would lead to a very low predicted risk. But then he made his own adjustments to the figures that he had been given on the basis of his findings. And he came to, at paragraph 57, to a conclusion that the total likely cumulative exposure over the 18 years of Mrs. Costello's employment will amount to 25.37 fibres per mil hours. He then turns to look at the effect of those findings on the predictive risk. And at paragraph 60, he concluded, consequently, on my findings, in broad terms, the defendant's exposure of Mrs. Costello over her working life at the Oil Sites Road premises increased her background risk from 24 cases to 28.39 cases, an increase of 18%. And at paragraph 68, having held that he would and should decide this case on conventional principles rather than on Fairchild principles, he held that Mrs. Sienkiewicz had not proved that her mother's mesothelioma was attributable to her exposure. And our submission is that, as a conclusion, that is amply justified, and the attack on it had failed in the Court of Appeal. Now, what it appears to be said now is that the level of detail into which the judge went was not necessary or justified. That is the phrase that my learned friend Mr. Melton uses in his case. I don't accept that. It was necessary for the learned judge to deal with the evidence that was presented to him, and it was necessary for him to make adjustments that reflected his findings of the level of exposure, which he did in the claimant's favour. And it was justified as at least a strand of the cable to support his more impressionistic finding that the exposure was very light. On the basis of my submissions yesterday, the court will appreciate that if Dr. Jones had come close to 2, there would have been scope for argument that the lack of precision allows for a possibility that in fact the actual increase was more than 2. But we submit that on the findings we are way off that, and that the trial judge's findings were reasonable and should be upheld.
Could you help me with the measurement, which I don't quite understand? ml dot hours, how does this?
Yes, the best way I can do it, with which may assist the court for later reference, is that there is what I believe to be a clear explanation of how this works in a marker which we looked at yesterday. I think at paragraph 3, it's tab 23 of bundle 2 of the at page 613 of the bundle, in paragraph 3 of the judgment of Chief Justice Martin, about halfway down, is a paragraph, the risk of contracting mesothelioma. Does my lord have that?
Yes.
And line 4, a dose may be calculated by counting the concentration of respirable fibres in an atmosphere. This is often expressed in terms of the number of fibres in a milliliter of air and abbreviated to the number of fibres stroke mil. Calculations of the cumulative dose of asbestos likely to have been inhaled by an individual may be made by multiplying the concentration of asbestos fibres in an atmosphere by the time that an individual was exposed to that atmosphere. So, for example, if you had a concentration of 6 fibres per mil, but it was only for 10 minutes an hour, that would lead to an expression of 1 fibre per mil per hour. Once you have the cumulative dose expressed in fibres per mil, the judge goes on to say the cumulative dose may then be expressed in terms of the number of fibres in a milliliter of air over so many years and abbreviated to the number of fibres per mil per years. And typically, to translate from fibres per mil per hour to years, you divide, Dr. Jones took 1920 on the basis of that being the number of working hours in a year, or one could take 2,000 or a figure of that order. Does that answer my lord's question?
Yes, thank you.
So, my lords, my lady, we deal at paragraphs 5.9 and 5.10 of the case on pages 29 and 30 with the Court of Appeal's transposition from the judge's findings to the Court of Appeal making rather different assessments. At 5.9, we point to the fact that Lady Justice Smith referred to the claimant's submission that the tortious exposure had, on the judge's findings, made only a modest contribution to the risk of mesothelioma. Lord Clark used similar language, and yet, as you will have seen from the judgments, Lady Justice Smith expressed the view that if the judge had asked himself whether the tortious exposure had materially increased the risk of Mrs. Costello contracting mesothelioma, the answer must be that it had. I take issue with that as an assertion. Everything about the judge's language and judgment was that he regarded this as very light exposure. And it was, on any view, a small percentage increase in what was initially a very small ambient risk, background risk. And I do not accept, and it's the reason why we're here, or one of the reasons why we're here, that the judge would have said that it was a material increase in risk. And at 510B, we point to the fact that Lord Clark said that it was either found by the judge or common ground that the tortious exposure materially increased the risk. And we do not accept that it was either found or common ground, because it wasn't found by the judge and it certainly wasn't common ground. So, in the light of the submissions in our case and the submissions that I made yesterday, we maintain what we say on pages 30 and 31, 511, 512, 513, which we set out there, and I'm not sure that it's of any advantage for me simply to read them out, to highlight them. You have the submission, and unless I can assist you further, I will move on to Willmore.
Thank you.
Which follows on in our case at 32, and the first thing that we do in the case is deal with the evidence of Dr. Rudd, but we dealt with that yesterday. I took you to the relevant passages and made my submissions on Dr. Rudd's evidence. The difficulty with Willmore is laid by the fact, or is in the context of the agreements that were reached, or the understandings that were reached, which meant that the engineering experts who were available were not called. But when the first thing that I would wish to highlight for the court is that although it is true that the claimant called a Lynn Welsh who gave evidence of more extensive, which could have led to findings that were of more extensive exposure, the judge expressly found that he could not rely on her evidence except when corroborated by other evidence, and he found that at paragraph 30 of his judgment, which in the bundle is on page 23.
Sorry, 23 of the...
23 of the bundle. I'm looking at Mr. Justice Nichols' judgment.
No. 23 of the appendix.
Oh, my lord, it's in a separate bundle. It's in the appendix to the statement of facts and issues in the Willmore case at tab 5. If your lordship has tabs, and at page 15 if you do not. My lord, by way of introduction to this judgment, can I take you, please, to paragraph 23 on page 21, where the trial judge set out the claimant's case on exposure at that stage, and there were five areas where exposure was alleged. The first was work on the ceiling tiles in a T-shaped corridor while the claimant and other pupils were in school and passing through that same corridor. The second was that it was alleged that the school was incomplete and that there was exposure as a consequence of completion of the original construction works. The third was the installation of a suspended ceiling in the junior block. The fourth was disturbance of ceiling tiles by pupils' misbehaviour, and that was apparently a trick that children had of taking clever children's satchels or jackets and lifting a panel in a suspended ceiling and hiding it behind. And that was said to have given rise to exposure. D, the disturbance of ceiling, sorry, that's D, and E was ceiling tiles in the girls' toilets. Now, in the event, Mr. Justice Nichol upheld the case on the basis that he found that it was exposure under heads A, D, and E, work on the ceiling tiles in the T-shaped corridor, D, the disturbance of ceiling tiles by the pupil's misbehaviour, such as I've just described, and E, ceiling tiles in the girls' toilets. The Court of Appeal held that his finding in relation to D was not justified, and therefore the court now is only concerned with A and E. Work on ceiling tiles in the T-shaped corridor and ceiling tiles in the girls' toilets. I mentioned Miss Welsh. On page 23, when reviewing the evidence, about 8 lines from the end of paragraph 30, the judge said there is some support for the claimant's account from Miss Welsh. And the court can read what he says about her, but at the 3 lines at the end, it was of some value when, as in this instance, it was consistent with other evidence. Where Miss Welch's evidence stood alone, I did not feel that I could rely upon it.
Can you help us with where we're going with this? Yeah. What's your submission going to be about all of this?
My submission is going to be, as outlined in the case, fairly fully, that on the evidence that was before the judge and the evidence that was reviewed by the Court of Appeal, there was no justification for making a finding that there was a material increase in risk from any exposure.
So this is an attack on findings of fact as refined by the Court of Appeal, is it?
It is an attack on the substratum of the findings, yes.
What does that mean? Sorry, the substratum.
It means that I'm asking you to look at what the evidence underneath the findings was, because the evidence underneath the findings informs the extent of the exposure in circumstances where no quantitative assessment has been made.
Well, is your submission that there was no exposure at all, or that we should conclude it was de minimis rather than material?
My submission would be that there was no exposure, but if there was, it was de minimis.
Well, isn't the latter something that would have to go back if nobody focused on a test of what was de minimis?
Well,
doubling ambient
the problem is
exposure or whatever.
The problem is that people did focus upon it, and there were, as appeared from the submissions to the judge, a clear understanding about what would or would not have been, or certainly what would have been de minimis. And our submission is that on the material before this judge and the Court of Appeal, it was not, there was no evidence to sustain a finding of non-de minimis exposure.
Was there any discussion of ambient atmosphere?
No.
But I mean, this is a single exposure case.
Yes.
You say Fairchild's no application. You say the test is yes or no. Was the atmospheric risk doubled? Nobody even looked at it that way. There isn't any evidence at all about all that.
And the reason why they didn't was that there was an agreement reached, or under an agreement reached, that on the claimant's evidence alone, there was not sufficient exposure to constitute a material increase in risk.
So that was an agreement between the parties
Put before the judge.
Put before the judge.
Where do we see this?
You see this in our case,
6.9, I think.
yes.
Where is it? What, point 9?
6.9 on page 35.
I see, yes.
Sorry, so I'm getting rather lost. So how were they going to win the case on this concession?
They were not going to win the case unless the learned judge accepted evidence other than the claimant's, which he didn't, in the event, said he did not.
Other witnesses of exposure not spoken to by the claimant.
Yes, if Miss Welsh's small Florida
Yes,
account
yes,
has been
I see,
accepted.
I
then-
see. So you simply say that the judge didn't give effect to what had been agreed between the,
Yes.
the
Yes.
parties.
And to that extent, I accept that it's an attack on findings of fact.
Sorry, did you tell the court this? The Court of Appeal this?
Yes.
So what do they say about that?
Well, they simply said, on the basis that any exposure to asbestos gave rise to increase in risk, they held that the judge's findings justified a finding of liability.
But how does that...
So they disregarded effectively what the parties had agreed, or overrode it.
We say so. We say so. And the sum total of the Court of Appeal's reasoning on materiality is to be found in paragraph 23 of the Court of Appeal decision, which is in the appendix to the Statement of Facts and Issues in Willmore at pages 5 to 12, and paragraph 23 is on page 11.
Sorry, Statement of Facts and Issues.
There is an appendix to the Statement of Facts and Issues in Willmore, and
Just the judgment, you mean?
at page 15, sorry, at page 5 should be the transcript of the judgment in the Court of Appeal.
Yeah.
Paragraph 23 on page 11. It is not enough, as Mr. Feeney recognised, to eliminate one source of exposure if another or others remain in place, because there is no safe dose of asbestos. Once exposure above a minimal level is found, as Mr. Justice Nicol found it to be in each separate instance, a risk of harm is established. I recognise that there is much in the judge's findings which depends on probability and inference, so that none of his findings was a foregone conclusion, even on the primary evidence. But for the reasons I've given, he was entitled to find the likelihood of significant exposure from 2 of the 3 sources he identified.
I'm sorry, how does that bite on the parties, you say, have a clear agreement that actually it is minimal?
Well, the argument before you, as set out in our case, is there was the agreement, section 6 point, which we've outlined in 6.9, with the references to the relevant parts of the submissions.
Yes.
What your case says is that the agreement was to the effect that the claimant's evidence, if accepted, was not sufficient to evidence material exposure. It doesn't relate to a material increase in risk, does it?
I would say they were treated as being identical.
Coming back to my suggestions, it would be much better to talk about exposure rather than risk.
Significant, well, there has been, when one goes back to Dr. Rudd's
Yes,
bifurcation of significant exposure giving rise to material risk.
Yes.
And we have set out at 6.11 the findings that the trial judge made. And we have set out in detail why we say those findings were not justified at 6.11 and 6.12, with the references to the evidence that was in fact given. And our submission is that in the absence of any evidence to the effect that asbestos was liberated by activities in reasonable proximity to the claimant, there was no proper basis for a finding of significant exposure to giving rise to material risk. So at least I got the bifurcation right in paragraph 6.13.
I'm not sure I fully understand how the points you're making at 6.11 fit in with the point you've made a few moments ago, which was that what the judge did was contrary to the agreement of the parties. I mean, I thought your point was that if the only evidence that the judge found was the claimant's evidence, and he rejected all the other evidence, then the agreement of the parties was that that wasn't good enough. But here you seem to be making a rather different point, which was the judge actually made positive findings which he had no business doing,
Yes.
because there wasn't the evidential basis for it, which
Yes.
seems to be a rather different point.
Well, but if you take out the findings which we say he wasn't entitled to make, he was left with a position which was clearly not significant exposure giving rise to material risk, as agreed by the parties.
So basically, what you are attack, you've got two stages. First of all, you stages straight attack on findings of fact upheld by the Court of Appeal that were inferential findings of the judge, who say he was simply speculating and shouldn't have done so.
Correct.
You've got to get home on that before you can then say all that's left falls within the agreement between counsel and could not constitute a material
Yes.
risk.
Were the inferential findings actually based on the claimant's evidence, which it had been admitted was not by itself sufficient? Many of them seem to have been.
I would say no, because they were, well, can we...
I thought you'd say yes, but
Only if I can. They're based on inferences. Whether they are inferences based upon the claimant's evidence is a different matter.
I see.
Because if we look at, can we look at paragraph 33 of the judgment? This is in relation to the tiles in the T corridor, where the claimant's evidence was that she had walked past and that tiles had simply been stacked to the side, and her evidence was clearly that she had no recollection of people actually working on the tiles as she went by. Paragraph 33, I find it was more likely than not that in handling of these tiles asbestos dust was released. This may have happened from the fashioning of tiles to make them fit the available space. It is fair to say that the claimant did not remember seeing tiles cut. That was her evidence. However, we know from the interdepartmental memorandum of the 11th of January 1982, which is 3 years after she left the school, that the cutting of asbestos board ceiling tiles was a specific matter of concern for the defendant's safety section. Additionally, or alternatively, asbestos dust could have come from friction or pieces of tile chipping off, Some handling was obviously necessary to get the tiles out of and back into the metal grid from which they seem to have been suspended. The 1982 memorandum makes clear that for some time the practices of workmen in the handling of asbestos products within the school had been a cause of concern to the defendant's safety section. So the judge, from direct evidence that she had walked past them, as she remembered, only once, and that the tiles were simply stacked at the side and no one was working on them, has created a finding on the basis of a memorandum produced years after she left, that it was more likely than not that the tiles were in fact handled so as to give rise to an exposure, a significant exposure, materially affecting her. He also found that the stacks of tiles would have been knocked or chipped by fighting children in the corridor, and that is in the second half of that paragraph. He says it would also have been consistent with these rather lax practices for tiles to have been stacked in the most convenient location, i.e. the corridor, while the work was being done in the ceiling void. The claimant and Miss Welsh knew about this because they were still able to pass along the corridor. If they could do so, other pupils could presumably do so as well. The pushing, shoving and fighting that the claimant recalled in the corridors is rather what one would expect. The likelihood that stacked tiles would get knocked or chipped was very real. Whereas in fact, the claimant's evidence was that she had given the workmen a wide berth, and there was no evidence of children fighting in proximity to the workmen. Her evidence was in fact that they had been told to be careful in relation to the workmen. So there was no evidence at all of stacked tiles being knocked or chipped, such as would give rise to the possibility of a release of asbestos. Still less was there any evidence of them being knocked or chipped when the claimant was near either physically or temporally. And the third finding that he made in paragraph 34 was that for all of these reasons, the claimant was exposed to asbestos dust in the course of the work on these ceiling tiles. I cannot, though, say that this lasted any more than intermittently over the course of a few days. Whereas, in fact, there was no evidence of the workmen working on the ceiling tiles so as to give rise to asbestos, and it was accepted by Mr. Allen that there was at page 192 in his submissions to the learned judge that there was no evidence that workmen had worked on the ceiling tiles so as to cause dust to fall upon the claimant. So that's what we say about the T corridor. The judge's findings in relation to the toilet block were at paragraph 53.
Paragraph what?
53, my lord.
Yeah.
Which is on page 27, going over to 28. He said he found that the claimant was further exposed to the risk of asbestos fibres by her use of the girls' toilets, because from time to time the asbestos ceiling tiles were damaged, and on one occasion at least ceiling tiles, some of which were broken, were stored there. To which our response is that there was no evidence at all given of stacked tiles being kicked, and the claimant's evidence was that the tiles were just there, was her phrase, and we've given you the reference for that elsewhere. He also held, at paragraph 51 and 53, that damage to the ceilings could easily have occurred. We say that that doesn't support a finding of material significant exposure giving rise to material risk, because there was no direct evidence of that damage, and there was no evidence of her being present when damage to ceiling tiles took place. And so our submission at 613 is that there was no evidence which would justify findings leading to a conclusion that there had been a material increase in the risk to which this claimant was, or this victim was subjected. And in those circumstances, we submit that to hold, as was held by the trial judge and the Court of Appeal, that liability is established under Fairchild, is effectively to do away with any requirement of material increase in risk at all. And that is why this appeal is here. Well, I haven't taken you to all the references because I anticipate that you would not wish me to do so, but the references to the understanding are set out at 6.9
Yes.
of our case. First of all, in line 3 of the submission, and then specifically in relation to each of the points that we made. And unless you ask me to go to them, I'm not going to do so.
But are you saying, I mean, I understand that you're saying that you're challenging some of the primary findings of fact by the judge, but are you saying that in any event, even on the basis, even if those findings of fact are withstand the challenge you seek to make, that a conclusion on the basis of that, as you would say, very small degree of exposure to asbestos dust couldn't form the basis of the conclusion that he reached at paragraph 57? Or does your challenge to 57 depend upon your challenge to those primary findings of fact?
It depends on the challenge because if one simply reads the words that the judge has formulated and made as his findings, he has made findings that there were releases of asbestos which would have affected the claimant on a number of occasions. And that is why, whether you call it a direct challenge to the primary findings or looking at the evidence that underpins the findings, we submit that the evidence does not justify a finding of material increase in risk. Does that answer my Lord's question?
So you say the Court of Appeal could not properly have held that this was a tenable finding so far as the first source was concerned, dust coming down from the tiles, and the Court of Appeal was wrong to hold that there's perfectly adequate material from which the judge could infer the
Yes.
breaking of tiles in the corridor.
I have to accept that if the findings are taken absolute at face value, because on the basis of the understandings, the engineers were not called to give a further elaboration of what would be material, that it is not possible for this court really to make an assessment in substitution.
Yes.
Unless I can assist you further, my Lord, those are the submissions.
No, thank you, Mr. Feeney.
No, my Lord, I don't follow.
Yes, Mr. Milton. Yes.
What I propose to do, my Lord, is shortly to go through the proceedings in Sienkiewicz and the denouement of the trial in a way that I cover at paragraph 31 of our case. So that's section D of the core volume. I hope that will assist the court because the learned friend has very recently been through the same exercise, and I can perhaps put a different slant on things and perhaps help also with the facts. So paragraph 31 should begin the facts of Sienkiewicz. Before I do that, can I just briefly alight on something, because it came up quite recently, and that was Milady Baroness Hale's comparison of the situation in personal injury law with that in family law cases, where one has to decide the often difficult task of which one of two parents may have inflicted injury upon a child. The distinction we will respectfully suggest is this, that in that situation there are two possible causal agents, the father and the mother, whereas in these cases we know that the causal agent is asbestos. If to adapt, but possibly...
Well, that's a bit like saying we know it was a hand.
Exactly.
Well, lady, if...
The question is whose hand? The question is whose asbestos?
It is, but in the situation whereby one knew that it was sufficient to have caused the injury for one hand to have inflicted it, so there's one bruise on the child, and that was done by one person, then...
A fairly recent case which has reached this court.
Then, in that situation, my lady, the court does have to make that decision, and there is no scientific obstruction to doing so. The only obstruction is a forensic one. But in mesothelioma, we know that the injury is not, by comparison, known to be caused by one hand, and that's the difference. If I could use the McGee case to illustrate the point, perhaps, if it was the case that a child was exposed without any breach of duty on the part of the parents, perhaps to sand or to dirt, but that each parent thereafter failed to wash off the child, and the child got dermatitis, because it so happens that even now we don't know whether dermatitis is done by a single impregnation of the skin from the sand that then spreads and causes the condition. Then, lady, you would be saying, perhaps in a different jurisdiction, that each parent had indeed contributed to the risk that the child would get dermatitis, and if the parents were being sued, or if it was others who were being sued, then they would be liable. So that, in my respectful submission, is the difference between the two situations. And it's, in my submission, an important distinction. It is the rock of uncertainty that was described by Lord Bingham in Fairchild and pertains even now in relation to three areas. One disease is mesothelioma, another remains dermatitis, and another, as Milady will know from the Griggs case, is or maybe PAD, the palmar arch disease case. But can I now do what I said I would do, which is to just look at what happened in Sienkiewicz.
What is your test going to be? I mean, what are you going to say? If we're going to look at all this, what are we looking for?
What I'm going to be saying, my lord, is this, that any material increase in exposure, to use Lord Phillips' words, suffices to show a material increase in risk.
What you're really saying is it suffices for liability, whether it is a multiple possible defendant's case, as in Fairchild, or whether it's a single defendant case, as in arguably each of these cases, although they're very different.
Yeah.
That's what you're saying.
It is.
Yeah. It's better just to be as straightforward as that, isn't it?
Yes, if I didn't put it clearly, then I should.
Well, you put it clearly.
Yes.
I just think you
Yes.
didn't take the
Yes,
next
no.
step, which says
Yes.
any material increase in exposure to asbestos is enough to ground liability
It is.
if mesothelioma is suffered.
But of course, that one question needs to be asked then, well, was what shall we treat as material?
Well, yes.
And I'll come on to this point, but I hope it may help if I first do go to the facts of this case. What I'll be saying is that one should not look in...
One should not what?
I'm sorry. One should not look in a mechanistic way at causation, but one is entitled to look at the context of the case and at the context in which the duty of care and indeed the standard of care is imposed. I'll develop the argument, I hope, in due course, but in a case where, as here, it was known, or should have been known from the 1st of October 1965, that any exposure to asbestos dust had the capability to give rise to injury. And once, from the 1st of January 1970, the asbestos regulations prevented exposure to any asbestos dust in the workplace. That background context, which is primarily relevant to the setting of the standard and duty of care, cannot be ignored and may well inform the causal test which the court requires. In other words, and putting it simply, if a defendant shouldn't be exposing a claimant to any dust whatsoever, that defendant can't later complain if a claimant gets the very disease that the creation of the duty and the setting of the standard was aimed to prevent.
Even if the employee was only there for a couple of weeks?
Even if the employee, as in Cox's case, was only there for a couple of weeks. Yes, my lord.
How close is the connection to be? This is basically saying you're doing what you shouldn't do, which is expose people generally, to asbestos. Right, so somebody who's got some connection with you gets mesothelioma, I'm liable. That's what you're saying. So how close has the connection got to be?
This is, milady, in fact, what happened in Pindar. Pindar was the case where Cape organised for the disposal of loads, massive loads of asbestos onto a council tip. And Mr. Pindar played on the council tip. The learned judge found that Mr. Pindar's mesothelioma was caused by asbestos exposure and by his exposure when he was on the tip. But, crucially, in the finding of Mr. Justice Ramsey, which wasn't appealed, the claimant as a child did not fall within the class of persons who were reasonably foreseeably likely to be affected by Cape's breach of duty. What he did say, and this is something which I may refer to in due course, in developing the idea that the asbestos in the atmosphere is not there naturally, what he said is that others who may well have been the beneficiaries of the duty of care, and may well have been in the contemplation of CAPE, were those affected by the transportation of the material from one place to the next, or those who used the public roads along which the asbestos was carried. So in answer to, or I hope in partial answer to my lady's question, what does the connection need to be? The answer is dealt with by the law when deciding whether the claimant in question is an occupant of the class of persons.
Well, that's a duty of care question. That wasn't what I was asking you. I was asking you a causation question.
Yeah.
Or are we just leaping causation completely, frankly?
No, my lady. We're not leaping legal causation, because we only know what we know, my lady, and the importance of dermatitis and the importance of mesothelioma is that we don't know the causal mechanism. We don't know whether it may be one fibre. We don't know whether there may be a threshold. In other words, a need for at least 2 or 5 or 10 or 10,000 before that crucial mutation, that crucial genetic mutation takes place. And that is the heart of the rock of uncertainty described by Lord Bingham.
So your submission comes to this, does it? That provided obviously the claimant or the deceased was within the reasonable contemplation of the defendant, as long as the defendant's negligent, it's really for the defendant to prove, and he can't because it's a matter of scientific impossibility, he's got to prove that actually his exposure wasn't to blame.
I don't think, with respect, Lord, that there's a burden shift. But if the defendant were to adduce evidence to that effect, then yes, the claimant would fail. Can I give, and it's slightly counterintuitive to, or it would have been, we now know that, subject to the grey area alluded to my Lord Phillips, any exposure to asbestos that takes place in the 10-year period immediately prior to contract, prior to the onset of symptoms, is to be disregarded, because the doctors at least know, or the consensus is, that it has no causative potency. Before that was known, if, my Lord, I had been in front of you, my Lord, and one was trying to make a robust finding, saying, well, it's obvious, isn't it, that since 8 years before the contraction of the disease, the claimant was exposed to a massive load of asbestos, one would have said, and one would have been entitled to a fine, almost as a matter of common sense, that had been the cause. Because in our minds, at least, we connect temporal causation with actual causation. But that would have been wrong. And so it is the lack of knowledge or the ignorance about the causation of mesothelioma and dermatitis that puts us in this difficult position. We are
just out of interest, how has science demonstrated that exposure within the 10-year period is not causative?
My Lord, because the nature of the genetic mutations which are understood to be the crucial,
And the time they take.
the time they take.
Once the train is on the track, as it were, the die is cast.
Yes.
Yes. Mixed metaphors. Yeah.
It is, and they are. Yes. And what I'd like to do in answer to or explaining then by reference to Lord Rogers' question, what I'd like to do is just to show briefly what happened in Sienkiewicz and to demonstrate the following really, that in the specific case, doubling of risk was not and could not in any way be used as a tool for proving causation on the balance of probabilities, and nor could it be used in the other way suggested, namely by suggesting that if there has to be a material contribution that closely equates to doubling the relative risk, then the answer is to be found in doubling of risk. So,
do you have a formula for material increase in exposure, for the word material?
Lord, it has to be material. And so, but I would say that in the context of a disease where we know that one fibre may be capable and where employers are liable if they expose to one fibre, then material means anything that is above background risk. And that is the easiest touchstone for the court to apply, and one that is safe.
Anything, however, fleetingly above background risk, you're not looking at 20 years background risk and 1 day in this negligent factory.
Well, it would depend, my lord, on how the day in the factory was spent, because although the finding was that a person in Mrs. Costello's position exposed to the fibres to which she was, on the judge's finding, exposed, increased her relative risk by only about 18%. The fact is that when she was so exposed, she was exposed to 10,000 or 1,000 times the concentration of fibres than that which, on Dr. Jones' evidence, prevailed in the general atmosphere.
No, but I'm just seeking clarification of what you say. You mean by in excess of the environmental exposure? I mean, are you talking about on any day or within some wider time period?
I'm talking about any day, my lord, because in the the point won't improve in any way by repeating it, but I just mentioned the way in which the level at which the duty of care and the standard of care are set.
You've got to have a breach of duty, and so it's hard to envisage a breach of duty which only releases one fibre of asbestos. The breach of duty is likely to be fairly clear, and then the question arises as to how far, as a matter of causation, it has stretched its tentacles.
That's precisely so, my lord, yes. But in practical terms, and for those of us who do these cases day in, day out, what one would not be what one would be very gravely worried about a case in which one could prove only exposure to one fibre in terms of duty, just for usual forensic and practical reasons.
What were you alleging? Breaches of regulations or?
Yes.
You were?
Yes, we were.
Do we have your pleadings here?
We don't. I'm sorry. They are summarised, however, in the judge's findings, to which I'll take you shortly.
Are you going to take us to
10,000 times point, which you've just made, by which I assume you mean that there's evidence that on one occasion she probably sort of walked through a cloud of it for a quarter of a minute, but nonetheless very intense. Is that?
Yes, that is it.
Can you show me that?
Yes, my lord, it's it's in the judgment at I think it's page 57. And it's paragraph 56. So, my lords, I would in due course, and the lady, I would in due course have been inviting you to read the whole of paragraph 56, but now may be the opportune time to do so. But
whereabouts in paragraph 56?
Sorry, it begins 6 lines down. In the light of my findings above, what
which are the key ones? Because quite a lot of these are rejections.
Yes. It's page 57, paragraph 56. What the learned judge had done was this. He had dismissed as not established by the evidence several sources of asbestos contamination. However, in relation to 2 specific places in the factory, he found that there had been such. The first was the garage, and the second was when she was walking along walkways on the factory floor. What the judge found in relation to the garage, you can see in the second line of Roman numeral 1, the garage bay 16A, second line down. For 30 minutes per week, she was in the garage. She was visiting a husband who was there. What happened there is dealt with on the last line of that page. Whereas the respondent's expert, Dr. Jones, had said that a fair average level of exposure would be 0.15 fibre mils. 0.1, the judge found 0.15. So that was the garage, and she went there for 5 years, between 1966 and 1971. Then, on the next page, so at the very top of page 58, Dr. Jones had prepared certain figures, but the judge did the calculation you can see there and found that she had been exposed to 16.87 fibre mil hours of chrysotile. Chrysotile, as my lords will know, and my lady will know, is considerably less potent than the amphibole fibres, of which chrysidolite and, for our purposes, amosite are the characteristic ones. So that was his finding in relation to the garage.
Sorry, how many hours was it per week? 16?
It was half an hour per week.
Hour, yeah, half an hour, is it?
Yeah. So, and I'll take my lords this afternoon to the table that we're referring to, because it is quite important. But then there was another source, and that was amosite, as we can see, Roman numerals, B, sorry. Amosite release from fair-facing boards, ovens, fireboxes and presses. Because in the factory itself, there were all kinds of processes going on, some of which released asbestos, and indeed 2 workers there died of mesothelioma. But what set Mrs. Costello's case apart slightly from the norm was that she didn't actually work in the factory, she worked in an office. And the way in which she was exposed to the contaminated factory atmosphere was on her daily passage through the factory, which, on the judge's finding, took place for about 30 minutes, I beg my Lord's pardon, 20 minutes a day. And then, and this is set out in Roman numerals 4, at the bottom of 58, given the fact there were no exhaust facilities, he says he would have assumed a great deal more potential exposure over each year than Dr. Jones had done. He says, at the top of 59, he would have thought that from all amosite sources in the small steel drum and large steel drum division, the figure to have been 10 times greater. Thus, I find exposure to have been 0.5 fibre mils. There's a misleading R in there. The R should be crossed out. 0.5 fibre mils for 17 hours. So 8.5 fibre mil hours.
Sorry, the hour should be there. It's per hour. Isn't it? 0.5 per hour over 17 hours equals 8.5.
Yes, I'm sorry, it shouldn't be the plural, is what I should have said. And so he found 8.5. That was about 10 times or more than what the defendant's expert had said.
And then he adds them together and he gets the figure in paragraph 57.
Yes, and he comes up with that figure in paragraph 57. Yes.
Which is the addition of the garage and the other one.
It is the addition of both. So far as the other one, the factory, is concerned, my lord, it wasn't as if the factory atmosphere was tested, as it were, and was found to be always at this same level. If I can use the word ambient, the ambient level or concentration of asbestos in the factory changed because there were episodes when there were blowouts or repairs to the machinery when the levels were higher. And so this was, as the judge said, the broadest of estimates as to what was the level of asbestos in the atmosphere and therefore her potential exposure.
But, I mean, surely by definition, any negligent or breach of regulation exposure would be exposure beyond the atmosphere, beyond the ordinary environmental exposure.
It would.
And so your only limitation, there isn't a limitation. You say any negligent exposure at work is material by definition.
I do, my lord.
Yeah.
I don't need to say that, in fact, in this particular case, because whatever the touchstone may be, I would say that if the increase in risk using the Fairchild test is 18%, or as it in fact should have been closer to 40%, then on any view, that is a material increase in risk. And I'll show why the 24 to 28.39 increase is probably wrong shortly. But the difficulty, as my Lord Phillips alluded to yesterday, is that when we're talking about events that happened in 1966 to 1971, it's already difficult to form even an impression. The judge formed an impression, and I don't say that if the law required him to go down this road, I don't say that he as it were, did it the wrong way. But what I submit is that really he shouldn't have been encouraged and shouldn't have allowed himself to be encouraged to make such specific findings, because it is so difficult to know what happened 40 years ago. And moreover, when in this case the defendant, although it was a big multinational company using asbestos as part of its processes, it was completely unaware of the existence or importance of asbestos until 1985, and therefore didn't, for example, inform or protect its employees in relation to asbestos. In that situation, it would be quite difficult, I would submit, for reliable evidence to be found to show circumstances of exposure to asbestos when those working there, even the boss, didn't know that they should have been keeping out an eye for asbestos. So things that might have had importance and might have stuck in the memory if they'd known, wouldn't have had any reason to stick in the memory. But as I say, if my submissions on the law find favour in relation to the Fairchild exception, then I'm, if I can put it, more than content with the findings of the trial judge. But it seems to us, and we submit, that in a mesothelioma claim like this, judges should not be encouraged to go down such a detailed inquiry.
Sounds as if you're doing yourself out of a job, Mr. Bolton.
Well, I don't mind, my lady. You know, yes. Yes, my lady, maybe. But these cases, as my lady knows, people who get mesothelioma die within 15 months most of the time. I think Mrs. Costello's case, we haven't agreed quantum yet, although we optimistically told the trial judge that we would at the beginning of the case, but it's probably worth about £80,000 or so. Mrs. Willmore, as you know, died on the day the Court of Appeal judgment was handed down. So these cases need to be done in a straightforward way.
About what was the size of the workforce at this
I think there were,
establishment?
At times it reached 2,000. It's in the judge's judgment. It's page 20. It's about 2,000.
And there were two cases of mesothelioma that were unquestionably due to tortious exposure.
And as my lords would see, and my lady would see, if they were to read my skeleton at the beginning, the approach that we took was to say, well, in a situation whereby a woman who is at a very low risk, if Dr. Jones' figure is correct, a 24 in a million risk, works for 20 years in an asbestos-contaminated environment and gets the signature disease of asbestos exposure, then as a matter of inference, following the invitation of Lord Justice Sedley in Bread, causation may well or should normally follow. This was part of the concern which we had in the Court of Appeal, or was expressed in the Court of Appeal, that is it in fact the case that 24 in a million chance eventuated, or is it possible that the judge, when saying that Mrs. Costello was not present at any of these incidents, or was only 20 or 30 yards remote from them, can only have been exposed to a small amount. But, as I say, the judge made his findings. It would have been, in my submission, an alternative way for him to say, what I have to decide is, was this defendant in breach of duty? There was the opportunity for asbestos exposure, the disease eventuated, and I don't think it was because of a 24 in a million risk. I think it was probably because of a 50-50 risk or whatever. Because, but
I mean, your argument would be the same if she'd only been there for, as you agreed, instead of 18 years, a fortnight.
It would, but on Mrs. Costello or on her son and daughter.
But we've got to try and find some coherent approach that might lead to assistance in other cases too.
Yes, my lord. I think that the answer is though, that we're sufficiently accustomed to dealing with de minimis, the words de minimis non curat lex, or material contribution, to leave it to the individual trial judges to decide in a particular case whether what has happened did in fact materially contribute to the risk. If, for example, yes, and as my lords and my lady will all know from trying first instance cases, what often is very difficult, and it may be that the judgment and the way in which the judge approaches the judgment has to be crafted in such a way, obviously, as to decide what is the crucial question to be answered in the case. So the judge will be thinking, well, I have to be satisfied about material increase in risk. What are the factors that will inform my judgment on that? But in my submission, not necessarily on Mrs. Costello's behalf, but on behalf of others in future cases, is that in a mesothelioma case in general, any increase in risk is a material risk. It is a material increase.
Should we adjourn until 2 o'clock?